Okay, we have been crossed the 22 members so far. Now it is 9:04. So quickly we are starting. I'm sharing the screen with you. There we have been divided this discussion into the two parts. That parts where first I'm going to share with you what are the changes, what are the direction has been given by the Honorable Supreme Court. What is the relevancy? Even though it has been started or it has been implemented, it means the PoSH Act 2013 has been implemented decade before December 2013. It is now May 2023. So it is more than 10 years. I have one humble request. Please keep your audio off so that because we are going to be recorded and this recording will be available to you by tomorrow. However, we are already or also available on live on the YouTube, so it will also available there where you can watch it. So that's why I request all of you keep your audio off so that there could not be any disturbance in the background. And secondly, in the second half, I will request all of you who want to be discuss and who want to ask the question, who want to opinionize in this open discussion in the next or the second half of 30 minutes. So they will raise the hand and I will get them on the screen. So this is now 9:05. Quickly, let's jump into the today's open discussion on the Honorable Supreme Court judgment on dated May 12, 2013. In this judgment, the Supreme Court has been given or specially directed the state government as well as the first central government, then the states or every union territory. It is defining that now, however, the government or especially the Supreme Court, when it is directed, then it was earlier or the first implemented in 2013, but since 2013 or till 2023, 10 years, it was not effectively implemented into the ground. When it come to the ground, so it is about the workplaces, and that workplaces it is extended or expanded to the every workplaces, which is from the shop till the your corporation, your organization, whatever is the organization, the law is applicable there. But at the ground, there are the reality something else. What was the reason behind that? We are going to be address that reasons here also, which I am going to be share with you. If you have some different opinion on those, the highlights or inputs I am sharing with you in the second half, we are going to be openly discuss on that so that we can reach on a conclusion at the end, so that everyone who has been joined or so far and later on who will be read this replay, so they can also get information and some activities how they have to effectively implement the PoSH provisions into their organization. So my name is Beer and I am the moderator for this today's open discussion on behalf of SBR HR Learning Academy. What is SBR HR Learning Academy? So we will provide you the links of our associations, links of our partners, links of everything what is about us, because here we have only the 1 hour, so I don't want to share that in the detail. However, it was started as in the SBR Learning Studio in 2015, providing the corporate services, and then after re-established into 2019, and next in 2021, the SBR HR Learning Academy was established especially for focusing on the HR people development and growth into their specifically enhancing their knowledge. So when it comes to the today, what we are covering here, so we have been picked for the 4 specially agendas or 4 points we are going to be discussed. Number one, it is important for we are here now after implementation of the PoSH provision. It is has been past the 1 decade, and in the beginning it has been started into the or it has been implemented. PoSH Act has been implemented in 2013, but before that, when the some circumstances happen and the honorable Supreme Court, State Court, they have given multiple judgments in reference to them which provide the guideline to establish this PoSH regulation or the at the workplace how it need to be determined. Second, how it need to be provide the solution or mechanism. So there are the multiple level of the events happen or where especially the PoSH Act is the law initially does not initiated by the law committee or the government or their law body. It is initiated by the Supreme Court especially. So that's why there are some landmark judgments, especially the Vishaka case, which is determining the ultimate way of how this PoSH law is going to be drafting a framework for the implementation. It started in 1997, and since 1997 till 2012, it took a long journey. After that, finally, 2013, December, it was implemented. PoSH Act was implemented. It was first into the some industries or maximum the broad or just industries and organization. Then later on, it was amended and it was introduced through the UGC also, then CCA. Then after it become expanded for the every workplaces. So everyone you may know about, I come to know that everyone are the HR professional and consultant and who are in the senior veteran into the profession of the HR or the related services. So I'm well aware, you know well about the PoSH provisions. What are those? So we are not discussing here. Especially we are covering here about the Supreme Court judgment, what guidelines they have been given. And now, how as in the service provider, how as in the HR leaders or the corporate leader, how you can assure the provisions into your organization against the sexual harassment at your workplace. Since 2013, there are the 2 and 3 amendment has been done, but however there are so far many amendments has been done to improve the provisions related to the PoSH, but there are 3 and 4 only. But after that, it is not a great way of implementing. So that's why the Supreme Court has raised the questions why it has not happened since 2013. It is now 10 years. So that we are going to be discover here and discuss. Then how you can ensure it properly, some ways I am providing here to you, I'm sharing with you so that you can implement that at your workplace. Then there we have as an SLA, as we are HR Learning Academy, we have a separate pathway related to the implementation of the PoSH provisions. We are the service provider also. So how we do it or implement it in our clients or in our customers, so that pathway I am also sharing with you so that you can implement the same way into the organization. The pathway which we have been established, like the companies of Coca-Cola, then Nestle's and some Tata Group companies. These are the reference of some names. So how we have been done it there, so that I am going to be share with you. So here is this the flow of this discussion, how it is going to be. We have divided into the two part. Number one, I'm going to share in the first 30 minutes all that which I have been described here into the agenda. And then second section, that will be for open discussion. So as I have been mentioned with you, so you all, if you have any question you want to be asked that, so you just have to raise your hand. And if you have any different opinion what I'm sharing, so you can clarify that. It is open for everyone to discuss, but there are some rules which you have to be keep in mind. While number one, please listen carefully. I'm sharing something which we are implementing or we have implemented into our clients. So that's why it will help you to implement that in your workplace. Second, let's come with the historical events in the 2 decades. What happens? Why it took, however, into the international stages or international platforms and the foreigner countries, it was already there are the workplace related regulation were available into the foreign countries. Instead, in India, however, there were the cases also, but the government never defined it to, or the regulatory never defined it properly. There should be a proper regulation for. However, there are the already existing IPC provisions are there. There are the 3 and 4 sections available under the IPC, where if any case of harassment happen, they can directly complain into under the IPC or raise an file and FIR. Secondly, if there are the industries, so there is one law which is the Industrial Employment Establishment Act. So that is providing also provisions related to the equality, any harassment, but there it required lot of struggle by the females when they are facing or they become victim related to the harassment at workplace. So then after, there was one important case happened into the state of Rajasthan, 2000, it is 1992, which is known as the Bhauri Devi case. This was one of the cases which totally changed the direction to establish an separate law related to the any the discrimination or any harassment happen with the woman at the workplace in the corporate life. When a woman come into the workplace or into the corporate life, then after the cases has been increased. So there it was the first event when it was broadly known or globally known, the case of Bhauri Devi from the state of Rajasthan. Then after, there was another case related to the, it was one of the case from the Arab bureaucrats or administrative services, the Rupan Deol Bajaj versus KPS Gill in 1995. There also, the Supreme Court has been given the judgments related to the direction. But in the case of mainly which is known as the landmark judgment in the direction and guideline related to the framework of the PoSH provisions, that was into the case of the Bhauri Devi, and which was into 1997 as defined the Vishakha guideline as the framework drafting defining related to the PoSH. However, after 1997, there were two another judgment has been held by the Supreme Courts. That was one appealed export promotion, where it has been defined the different how it need to be determined that what should be considered as in the harassment into the workplace. Like, is there any personal connection, is there any physical contact, is there other things? Then Medha Kotwal, Lille and other Union of India case in 2013. These are the 5 events which determine finally the guideline and framework of the 2013 the PoSH Act. However, when it was implemented by the authority in the hurry. There was one case happen also in the 2012 Delhi. So everyone may be aware about that case. Then after, this was implemented overnight and there was many loopholes. However, when you see mainly the act or the law and its rule, that is not determined properly what you have done. That is just defining the 4 things what you required. You required one policy, second you required a committee, third one, then you have to be comply with, you have to comply with the submit some the document have to prepare, but how you have to prepare, how you have to proceed, and where especially the mechanism was not there. When this 2013, the 9 December 2013, this PoSH Act 13 was implemented, and then after it, you can say at the dark side, because it took a long time to reaching at the level of a separate law related to the securing the dignity of women at the workplace, their right. Then when it was implemented in 2013 December 9, then after the 4 and 3 events happen where something has been added on the different stages, then you can say it as a bright side of the implementation where something the female feels that it is secure, but that still after there are many loopholes. There are the studies also happen when if any case of harassment happen and the victim she complain into the committee, or either there are the 2 level of the committees, one is your internal committee, that is second one is the local committee. If any woman who were the victim and she complained into the committee, either there was not the proper mechanism solution provided to her, or even though it is the studies also said that the after the complaint their condition become more worse. So that's why what the judgment we are discussing here today, that is especially about filed in 2014, even after the 6 and 7 months of just implementation of PoSH Act 2013, because there were already the loopholes. So there was one case happen into the Goa. So this Goa is the case is especially from the Goa, and what is this final judgment. We are going to be discuss it here so that you can get the proper guideline. And next, it has been thoroughly now described by the Honorable Supreme Court, but especially you need to be do to ensure proper workplace security for women against the sexual harassment. So in the 2013, then it become your Sexual Harassment of Women and Workplace, the Prevention, Prohibition and Redressal Act. So it is providing the three mechanism now. Number one, the solution, how you have to be prevent. Even though it has been provided, you have to be prevent, but the path, the way, how you have to prevent, it was based on the interpretation either who is the service provider or who how what is your understanding based on your learning has been done either thoroughly reading of the law or you have been just consult with any advocate or who are the expert into that. It was based on, so that's why it was not equal practices in all the organizations. Then secondly, it was if it is happening, so there how you can prohibit it at your workplace. Third one, if these two provisions you have been done, but at the level 3 there the mechanism how you have to provide the solution and conclusion at the end. This was the objective of this kit. But when there are the other provisions which required, but how you have to be do it, how you have to provide the mechanism. So I'm well aware, you know, there are the provision of the complaint, then after there are the you have to go with the inquiry, so that inquiry required to be 90 days, then after the report finding what are the recommendation has been done and conclusion that need to be implemented by the employer. So ultimately the employer is responsible behind the all the provision which has been prescribed into the PoSH Act. But after that, even though there are the penal consequences also available, there was the around 50,000 rupees charges if it is not implemented. Or then after it is a second time also, then it can be double or up till 1 lakh rupees. However, there are many judgments has been held or many cases where the organization has imposed with the fine of 1.5 CRs also. So then the provision has been provided what you have to do and how you have to, what has been defined into the PoSH Act, but how you have to proceed. So there you have to be follow with the different guidelines, different notification given by the, like in the 2015, the Department of Personnel and Training by the Government of India, Central Services, it was defined how the inquiry need to be initiated. So you have to thoroughly go to the CCA, what are the provisions under that. Again, your interpretation, how you can understand that, interpret to your customers now. Then 16, it was expanded to the 2016 for the UGCs, the notification provided for all the educational institution. So it should be implemented there. And in 2016, the one event where earlier it was the internal committee, but 16 it was defined as in the internal complaint committee, means where the victim, she will file the complaint into the organization. So it was specially for the corporates. Then in now, after 10 years, 2023, the ICC still not effectively implemented into the organization workplace especially. So after the hearing since 2014 till 2029, concluding the case, the Honorable Supreme Court find different types of the deficiencies into the provisions. So that's why provided the direct concluding guidelines. What need to do now the states, union territory, as well as the central government. But they can do. Now it is also open to them. There are the many judgments which has been held by the Supreme Courts, but still not implemented, even though there are 20 years has been happen and passed after the judgment has been done by or held by the Supreme Court. But now here it is the role and part of the you as the human resources leader, you as the consultant, you are as in the leader of HR or business leader, you can ensure it your workplace, because at the end, if there are any consequences happening, it is impacting to you. So how you are going to be, how you can do it better, so that I'm going to share with you. So when the law was especially implemented, so it was providing the two types of the securities to the women at the workplace. One, it was assuring what was is expected. However, it was not defined and defined in the law thoroughly how you have to be ensured. It was just providing the 2 and 3 liner of the input what you required. So it was providing especially the hostile work environment should not be there, you need to be prevent. But harassment is not just an hostile, but it is above to that and below to that also that need to know. But further there are the many little small amendments has been which is defining under these four. events has been happened after 2013. Second, it was the understanding the unwelcome behavior, what it should be, what and how that victim she can determine, because at the corporate there have the different types of the behavior of people. Sometimes it is acceptable, sometimes it is not acceptable. So how to determine what the receiver perceive and how he now determining or interpreting it, that is on the fate of that victim also. So that's why there are also the chances available where the advantage of this law has been taken by the females against the male in case of the harassment or the false cases has been initiated there, and that given the different types of the consequences for the who was not the involved into the cases. So this was expected, but still now when the court has been held this judgment on the May 12 2023, it was now a significant, just like in 1997 the Vishaka guideline was given and landmark for the PoSH Act, but this is now the significant judgment clarifying. So that's why it is around 56 number. We are going to be send the full copy of the judgment to you through the thank you mail, maybe by tomorrow morning, or otherwise our team will send it by today in the after conclusion of this discussion to you, so that you can thoroughly go through this, you can understand it properly, and prepare yourself to what you have to be or what you have to do into your organization to conclude or implement the provision, and what modification you have to be do now. So it is providing the 6 and 7 types of the provision what you need to be do. So first of all, when it is a putting by the judgment and it has been held, so that is defining here you required some verification, time bounding, the frequency you have to define for the provision you have been implemented, the practices you have been done. So there is, as of now, there is no time bound verification. For example, if you are working into the factories or manufacturing, there are provision, or even though the social security, ESIC and EPFO, there are already the provisions related to inspection. So every 3 year or random basis they can go for the inspections also. If any case happen, if they can track something, so it will be inspecting, and finally you will, the agency will quote you if there is some deficiency on the compliances part. But as of now, however, the PoSH Act is regulated by the Ministry of Women and Child Development. So that's why there is no regulatory for the verification, the time bound frequency based regulation. So that's why the first direction which has been given by the Honorable Supreme Court in this judgment, so that is required the time bounding verification. However, maybe next the Ministry of the Child and Women Development, that can put the notification how it is going to be regularize the inspection and verification. But furthermore, it is important for you how you ensure it at your workplace, in your organization, so that there can be zero cases of the sexual harassment at the workplace. Number two, which is one of the important judgment or direction has been given by the Supreme Court or Honorable Supreme Court in this judgment, that is the transparency required. As of now, we have also worked, or we are working for the many organization, they have implemented it, they have strongly done everything at the stage of the implementation, communication, everything, but they are hiding it. Whatever the policies you have been prepared, whatever the guideline you have been defined, so that is just for a picturing one day, then keep them or kept them into the files where they are into the dust. But now this has been caught by the Supreme Court while the hearing has happened for the around 8 years. So they have been, or Supreme Court has been directed, especially the organization, they need to be detailed, published into their website. It should be open to everyone. Their relevant rules, their policy, what you have been defined, how you are putting the mechanism into the action, what are the consequences it may be if someone involved into the case, so that you have to be put into your website also, so that it will be visible for everyone where when they want. So as of now, if you have the committee already, there are around 98% organization who are still hiding this information. Only 1 and 2 organization who are totally open into such cases or the such provisions or related to the harassment. So they are assuring, or they are especially the zero tolerance against the sexual harassment. So they are now having the zero cases. How? So I'm going to share that at the end with you how you can ensure. Number 3, what is directed into this judgment by the Honorable Supreme Court, that is required now the widespread verification. It is required everywhere. So verification does not means only into the ground of your the corporation, your big organization. It is everywhere. Either that is your college, hospital, nursing homes, whenever, whatever is the workplaces which come into the definition of workplace, either that is the shop who are or who are engaging the employee or who are engaging the workforce, it will also available, and the same verification step need to be implemented. Third one, which is already there, but now this Supreme Court has been directed that the sensitization and education are required to be repenetrate into the organization. So that, however, the organization, when it is started in 2013, then 2013, 14, and 15, in the 2 year, many organizations they have with rush go to the policy preparation. Then after 2 and 3 year, when it come to the stage of maturity, so everyone forget that. So that's why it is required and directed that now your sensitization education and programs that need to be reinitiated. You need to that regular workshop you need to be required. Your orientation program should be within a frequency, either for the new employee or for your existing employee. And further that, most of all, there is required, the direction has been given, you need to be strengthen your ICC, because ICC is the internal complaint committee as per the PoSH provisions, is the autonomous body which has been provided the same rights as the district court or the lower court. So they have the neutral judgments rights also, but the organization does not allow that to the agent or the ICC. They can initiate such, because everyone are the employee, even though who are the member of the ICC, they are also employee. So if anything, they will give the right judgment in the case. So the employer can also sue them. So that's why there is the reason, and these reason has been highlighted and produced into the Supreme Courts. The Supreme Court has been given such judgments, and finally it is already there, but it is going to be more strict to the organization, the penal consequences if there are no adherence. The organization are doing, as of now it is the first time 50,000 rupees, and then it can be double of that direct penalty by the district officer. They can, if it is the case, come into the court, and then after court will
Right.
decide based on all these. So then now it is coming with the how you have to be based on these provisions which has been directed by the Supreme Court, how you, what you need to be do, what is defined, how you have to be considered. So here we have been pointed out the main 6 to 7 number of the points which you need to be focused on, which you need to be check into your organization. Are they existed into organization? You need to be remodify that, or if it is not there, so then you have to be implemented. However, as per the provision, it has been provided only the 6 week of guideline to the government. They need to provide the next notification and the proper guideline under the PoSH provision or the direction of the Supreme Court. So number one, there is a required, like you have to be reinitiate the workshops and regular upskill to the internal complaint committee members as well as your employee, everyone, because sensitization need to be done by the ICC to every employee. So frequency you need to be decide. Then where the second, now the verification part, it was not already there. So it has been now directed that the inspection should be there. So the ministry will come with the notification of the proper notification when it is going to be come for the proper direction on the verification how you require to be initiate. Third one, it is at the national level and state level develop the module to conduct the workshops now. However, it is depend totally on the organization. So far they are conducting it, either there are some the bodies, individual body like the consultant as well as the service provider, they are conducting these workshops. But now the Supreme Court has been directed the national level as well as the state level, there should be conducted the development modules to organize the awareness program for sensitization, either into the government agencies or government enterprises, government offices, as well as the private sector everywhere. So it means now the your district officer, they will be more closely directing these cases. So there are also the new chances of the any type of corruption may be happen, but still we cannot say it what it will be going to be happen at the next stage. We have to wait that, but important part and the understanding or the action is for you as in the corporate leader, as in the business leader, as in the human resource leader, as in the consultant. So whatever the provision has been directed, you have to be implement that, you have to be assured that, so that you cannot face any double consequences which may come into the future. So then third one, the fourth one, which is a defining, so it is directing to the everyone. Everyone means where it is about the central government, the state government, union territory, and the government body. So government body as of now, the authority is the district officer. So there you need have the certain, or they're creating one IC members. The data need to be along with. So there will become one the portal where every ICC from the organization, they need to, you need to be float that information on the central board. Like there are the Factories Act, there are the other acts. So there are, you have to be submit the detail that will be live available. So as of now, when it comes to the many organizations who have the policies there, which we have been experience, and then they have the committee. Who are into the committee? Two-person from HR department, one from their reception, and someone from the department who are good to them. So these four members are there. And fifth member or your external member who has been good to you or you are the known to. So they are only just doing the formalities, but that you need to be controlled. Otherwise, you will face the more legal or the consequences under the provisions. Then fifth is there you required the internal policies. However, as of now, you have the policies, but with the policy, there are the other policies, employment related policy, which is also required. The earlier, the four amendments or the amendment has been done under the different agencies or different government bodies. Either it is UGC, it is your the Department of Personnel and Trainings also, it is your the amendment of 2016 under the PoSH Act, where the IC name has been changed to the ICC. So there it has been defined that the internal policies, either your recruitment, your the where there are the chances of the discrimination, or there are the chances of biasing between the boss and subordinate, so that you need to be assured. So that's why, however, earlier it was available there where you have to provide the guides into or guideline into your policy, and that policy defining that you are or your organization is against the sexual harassment, or you are have a policy zero tolerance against the sexual harassment. So there has been given the time where the every state they need to be assured the provision which has been the guideline direction has been given by the Honorable Supreme Court. The time is 8 weeks. However, it is just 3 days or 4 days has been already passed, but still there is nothing happen. But in the background, the government agencies, they are doing something or not. So it will be depend on. So now it is the how you can ensure. So quickly, I am just binding in the first section by 4 minutes. Then we are going for the open discussion. So when and how you are going to be, you have to be ensure the 4 level of the provisions, so that you can ensure proper implementation assurance of your PoSH provision. Number one, you have to create the base, strong base. So strong base will be come from you, your policies, your procedures, that you need to be re-verify what it has been said. Your policy are that really according to the provision which assure zero tolerance, zero cases into your organization. When you have been done all that documentation part, then you have to be connect and create a belongingness within your every individuals. That will be put through, and through your ICC you have to make strong your ICC. Then you have to be provide the mechanism, you have to be make, you have to be build, you have to develop the capability of your ICC member to assure properly. One is the mechanism in case of if any complaint happen, or secondly assuring it on time to time there is the regular compliances. So these 3 stages, many organizations they have had been done it while they have been engaged the top level of expert into that first phase, when it is started from the documentation, when it is started from evaluation their system, as well as evaluation means their policies where it is required. Then third stage, implementation. That was a great job done by, but after that, when it has been implemented, the stage of maturity never cleared or never reached into the organization. So that's why it has been failed. So now these are the 4 stages you need to be sure. And now with this direction, this maturity level is defined what you had to do. So you have to thoroughly go through the provision of this judgment so that you can understand it. However, there similarly, okay, someone is raising the hand. Wait for 2 minutes. I'm going to be close it. So then after we are going for the open discussion. So there we have a also the education provider, we have also the service provider into the post. So we have the four level of compliance implementation provision related to PoSH, where we are initiating all those four levels. It is your base strengthen, either your belongingness insurance into your organization, a foolproof mechanism, and finally the ensuring the maturity, where you have to define the step after 1 years, that is ensuring your maturity, so that you can have, so that way how you can be considered. We have the four level of system, which we have been broadly divided into the three level. Number one, that is going to be pre-implementation, where you have to be check out all your policy procedure which it has been defined. So it will be number one, whatever your policy is that rightly defined, what is required, so that you have been done. Second part is the implementation phase. What level of implementation you are going? Either it is just for the formality, or you are in the real ground event ways you are going to be happen. And then your committee members, are they fully trained under the provision of the law? And then after 1 year, your two level, one is the mechanism for the case if happen, and secondly the regular mechanism, how you are penetrating and sensitizing based in the either in the quarterly base of frequency you have to be defined, so that you can implement into your organization. So therefore, who we are, so we will share with you the next formats, so where and how you can implement the provision of the four level, and that are especially the pre-implementation, what types of the stages you can do. And second, it is about the implementation, what you have been done and what are the gaps. So one a write-up we are going to be shared with you through email by tomorrow, as well as the after the implementation stage, the maturity level, how you have to be assured. There are 3 and 4 level of the activities. Then furthermore, we have also some the level 2 learning is also there, so you can also check out that the information will be come to you. And then it come to now the it is 9:41, come with the discussion. So anyone who either you have some different opinion, or you want to ask any question, so you can ask it here. So here is Vibhakar has been raised the hand. So now I'm going to open you, I'm pinning you into the screen now. Yes, please. Welcome you here into this open discussion. I personally welcome here Vibhakar Ramitakar. Welcome you here. So now, you have any question? You have any opinion for the audience today?
I have some suggestions
Okay,
for
please.
Amendment to the Act. Firstly,
Okay.
is said that it is applicable to organizations where 10 or more employees are working. Whether they are male or female, that is not clear. Secondly, committees of 4 persons. Actually, it should be an odd number, 5 or 7. Because in the crucial stage, when the opinion is divided 2 and 2, then what decision is to be taken?
Okay.
Thirdly, many companies say external member has to be woman. That is not correct. Whoever has got knowledge about this, who has worked for the women organizations,
right one,
he can be external member.
Yes.
Then whom to send the annual report? That authority is not prescribed in that.
Yes.
Then who is the governing body? Who will ask the employers, why have you not implemented?
Right.
For labor acts there is, but for
Yes,
this act there is nothing.
Yes.
Then qualifications for external member, because what I observe is, if I quote 10 rupees, another Tom, Dick and Harry says I will do it in 8 rupees, and organizations appoint that.
Yes.
But when there is a complaint and you have to deal with it, it is very delicate matter and they cannot.
Yes. Yes, right. You are right.
So there should be somebody who conducts examinations and gives qualification.
Yes,
Then awareness programs. Awareness programs also have to be prescribed, because many members, they only say some few things and that they call it an awareness program.
Okay.
It should touch all aspects.
Yes.
Then sexual harassment of men, that is not provided anyway.
Yeah.
Not even in the IPC.
No.
So that should be, because in these days when Supreme Court is dealing with lesbians and same-sex marriage, etc., this point is also important.
Definitely.
Then beauty parlors, hospitals, educational institutions are, very delicate places where, immature girls are working or they are doing this.
Yes, please.
So there should be there is a thin line. So definition of sexual harassment can also be amended. And lastly, punishment. In the standing order, there are only 3 punishments: warning, suspension, or dismissal.
Right.
Here, any committee is giving any punishment. So punishments also have to be some, guidelines for that.
Yes. So, okay. So just I'm clarifying whatever the points you have been read, that all are good points and that need to be considered by. However, when it was held into the, since 2014, the case which was held by the Supreme Court now, so there it was specially identify the certain cases or all those the issues which you have been raised. But when we when it come to the first law was implemented, so there it was never in all the, either that is the IPC, that the other laws into the, instead of the employment law or the industry law, there are no such provision directly defined. If there is the conclusion defined, so it there would be no reason for any interpretation, taking any chances for the 8 to 10 or 20 year finally concluding the case. There should be directly everything done. This need to be done as an SOP, standing operating procedure. However, there are the now chances how the organization have to ensure. So there is the provided some guideline which is as per the interpretation, either the resources, either the agencies, either like the consultant, it will be depend on their interpretation and how considerable by the organization, especially because organization does not consider it as a serious matter. So that's why they just complying it. That is a one of the issue which I have been earlier also told. So when it come to the organization, the committee first, even though when it come to the committee, there it has been already prescribed on the different level. If you go not in the case also I that the UGC direction also, however there are provided it for the 10 or more, but there are the two perspective you need to be considered. Perspective number one, applicability of the PoSH Act 2013. It is applicable for the every organization, either you have less than 10 or above than 10 employee, male female, it is applicable to them. The condition is where it is applicable for the 10 number, above to the 10 number, that is for the ICC. There are the two types of the provision available. One is the complaint committee, which is under the your the district officer. So that is on the taluka basis, local basis, your the ward basis, but you have to be checked out because direct or the broad guideline by the state is not there as of now. So that's why there is the lacking point. So the Supreme Court has been guided this direction. That was the issue. So why the Supreme Court come into that and this direction has been come. This is the main reason. Then it come to the committee. Committee is available for the 10 and more employee, ICC. There are the two types of the committee. One is your complaint committee under the the district officer, under the government body. Second is by the organization. That committee need to be constituted by the corporation, corporate, your organization, whatever. If there are more than 10 employee, if there are more than 10 employee, you have to be constituted, either that is men or women. Then it come to the next one, which you have been queried about the members. So minimum requirement is the 4 member. There two should be your employee representative, one is your presiding officer, one should be your external. 4 member are the mandatory. But now how much you can expand or what number it can be, so you can expand it up till 19. The practices we implement into the organization up till 19. So where it, if there you have the 3000 employee working on a one side, so it cannot be 4 member. You can give the representative more than, or you can define the group of people or number of people where you can group them, there you can define the representation for them. So at least 19 maximum number you can have. So one question or one thing which you have been opinionized, so that is about the, it should be into the odd number. Obvious, that is there in odd number. So it is kept open. It is 19, 19, not 90. It is 19. So it is opinionized that the member always should be odd, because under the committee it has been defined, or law provision where you have to be go through the either DOPT, there is the 6 number of the notification has been given. UGC has been defined 2 notification. Then after the 1 and 2 amendment has been done under the 2016, where the committee name has been changed to the ICC to the IC2, internal committee to internal complaint committee. So that you have to be thoroughly go. So that's why it was not provided the proper guidelines. So still that as the issues there, even though in the future it will also happen when the new guideline come from the government authorities. So there it is maximum number you can implement, or as a committee member 19. So similarly we are working on the same guideline also, where you can be get that properly. Then third one, you have been asked about the institution and education where the female, however there is no deadline. which need to be it is open for the organization, either that is your manufacturing, that is your corporate, that is your institution, that's your academy, that's your parlor. There it will be depend on your the policy, how you are defining that policy, what you need to that. So what I have been shared with the 4 level of working you have to do, you have to be strong your base. Even though we also assure that or guarantee that there are the big number of the expert who never take care of the ground working strong the base. What are the employment policies, where are the loops available, where can the harassment happen, where can be biases happen. When the biases are there, when you have been identified those biases, however there are the provisions also provide quid pro quo, which has happened into the bias subordinate and the boss and subordinate. Maximum cases, 90% cases are happen between these so far, which has been identified as a case on the sexual harassment that has been happen between the subordinate and subordinate. So there was the case of the quid pro quo. It is either biases, I'm giving to you if you favoring this thing for me. So that is the case. So that is, there are the provided, however, the three the major mechanism to ensure at the workplace. One was the prevention. So it will be your guideline, your policy, as well as your trainings that will defining your the how you prevent it. When you have the provision there, you have been sensitized at, but then after it is happening, because we are the women, or we are the human beings. Human beings, what we have been taught today, tomorrow if we are not practicing that, day after or week after 1 month, we will forget that and we will come into the same stage. So there are the second provision. If it has been happen at the first stage, the prevention you have been done, you have directed, you have sensitization, then it is not there, then you have to be defining your document that is about the prohibition. If you are doing this, you will be get this consequences, and we are not accepting that. Third one is now the mechanism. So that's why it was put on the committee. So committee was given the right as in the court, similar light, questioning, inquiry, but they are also the employee. They cannot go beyond to the direction of the management. So that is the point of the lacking of implementation such directions. So these are the provision you can implement into. For that, if you need any guidance on that, you can connect with our teams also, so they will provide you the guideline as well as how you can be further do it on. So is there any further question by someone who want to ask or who want to opinionize? Okay, Radha, please, you can unmute yourself, as well as I'm pinning you here. Just open your video. Radha, welcome you here.
Good
Yes,
evening,
please.
everyone.
Good evening.
Thank you, SBR Learning, for such a wonderful session.
Welcome, ma'am.
And though we are all discussing about law, so yes, we know the law, how it's coming up with a lot of notification and amendments. But once it comes with the implementation in the organization in a practical way, all of us know that we are working virtually also, right? Here the challenge comes for the trainer also, that make them understand different type of a behavior or inappropriate behavior through virtually, because these people are not opening their cameras. So for a trainer, yes, it is a challenge. So the law should give such guidance that until unless it's not an emergency, everybody, at least for the first time training, should be offline the first time the participant is getting. See, if it is a periodical and you have got number of times, so you can go for virtually, right? But the participant who are new joiners, they are the youngsters coming from college and joining the organization. So being a trainer, I have this challenge, right? Yes. To actually demonstrate them the inappropriate behavior. By words, yes, we can, but how much it touches you here, not here in heart, but here. So yes, it's a very much challenge. Yeah, second thing, when we talk about implementation, as you said, that we forget, if we don't practice, we forget tomorrow or day after tomorrow. Yeah, right. Yes, 100% right. So being an external member, wherever I'm working, I am connecting these PoSH services with the engagement activities of the employees. So it will be on a very frequent basis on the special occasions also. Here, I think the learning is fast, learning is very willingly, and they understand their colleagues also. And I mean, they understand why actually we need to adopt that, not with the force, but with the willingness.
Yeah.
So I suggest everyone who is here to connect this PoSH implementation with the engagement activities, maybe certain type of, you can say, competition.
Yes.
Recently, I have got it done with one of the leading organization. So they participated very enthusiastically, and the results were very good.
Right, ma'am.
So these small activity we decide in our quarterly meeting.
Yes.
And every month, at least there should be minimum one activity related to that. So that will become the part of your behavior.
Yes,
instead
definitely.
of just for as a law, they need to give the attendance.
Oh, yes, ma'am. So here, just
that's it, and rest you can put your own views on it.
Yes. Yeah. So thank you, Radha ma'am, so for your valuable input on the how organization have to. When we talk about the perspective of the law is just for a guideline. When we are going for the organization are totally free. You have to ensure it. Never the law will come to you. Till then it is not happening, or never you are going to the law, it is implemented. That is, the guideline has been prepared. Now it is the role of organization how you have to be ensured. As the beginning I have been shared with you that you required the strong your base, how you can ensure that. So that is about your, there has been provided the guideline about the policy. Number one, you have to assure it into your policy. Based on that, now you have to engage the external member, like you are the trainer also, you are engaged into, you are frequently going to the trainings also. But till then it is not done by the organization when you are not penetrating the management. What we do for organization when you are going for the, just I have been shared with you, hey, this 4 level, what we do here, we specially include the 4 levels of the your employee, that are number one, your document, who has been the authority matrix. So first one, we pitch it with the your management, because it need to be directed, it need to first one into their management mind. You need to prepare themselves. If you are doing everything, training is also, it will not happen. Till then you are not engaging your management. Without management it could not be happen. So it is important for you that the it or your PoSH implementation will be effectively implemented, utilized into the organization when you are penetrating it from the top. So number one, you have to be bound them. Second, there are the another reason also, because organization has hired the external member. Organization can initiate in direct the external member what you have to do. They are getting it right. But at the end, there is the part of the committee. You need to properly guide. You need to be prepared your committee, so that, because that is the autonomous body, and that autonomous body will assure your foolproof mechanism or implementation, even though further the maturity level, as ma'am said. So after 1 year, in the 6 month or 1 year, you can do it better. But at the level of your maturity, second year, third year, it is the issue. So that is the reason where it is not properly penetrated from the top to bottom, bottom to up. So here you have to be make strong your committee, either as an external member. You cannot do it by yourself. So you have to be strongly connect the committee, even though the organization, they do not allow you more than 2 times into their organization to visit. And secondly, you have said that you have to be first time like the virtual. This harassment happen between the subordinate and superior, either that is virtual or something happen. So there you can do first time, create the physical meeting into your premises. Secondly, not go to, you have many platform, free of cost platform, where you can put that recordings, give them that recording. After that, evaluate them through online. So that can help you to save your time and getting the right kind. So there you have to be autonomous or automate that function, where what is the time they have been taken, and within that time what are their, it can be objective type or somewhat subjective type also, you have to be track. So there the psychometric you can also use for that, so that you can understand their mentality. Many times we are also conducting the training, even into the training room there are the 50 number of the person or people sitting. So out of that, it is the trends also, 50% of the people, they are in their mind there is something else is running on. So that you have to be tracked. That is the way where you can, one time you go for the physical, it can consume your time also. Secondly, the recording put on some platform, then you just give them every month, they have to rehash this, they have to refresh it. Based on that, you have to be evaluate their time keeping, what time, what tracing they have been, what new they have been, so their opinion as you have to be tracked. So that is the way to you can penetrate more furthermore, and secondly you can save your time also, your organization time also. That is a little bit thing we consider that it is a right way where you can that challenge, or you can have some input or insight on the time where you can achieve whatever you want to which achieve as an the target of the where you want to focus that especially on their mind, because it is not the matter of heart. But before that is a matter of heart, then it becomes the matter of mind. So that's why if there is the consequences happen first, the victim she will be lose from the mind first and then it is the heart
Very
also.
rightly said.
Okay, thank you so
Very
much, ma'am.
rightly said.
Yeah, so these are the actual issues we have been faced with the organization. We have been we have a client like the PepsiCo, we have the Coca-Cola, like Tata Group companies and Nestle also. And those organizations, when we prepared, our expert also, we were also there. So when we prepared, so we penetrate with the boardroom first, even though there are the Companies Act that is also providing where the your director they have to submit the annual report under the to the registrar of the companies. But that is similarly you are preparing, but they are further also required the guideline, which is the guideline here directed by the PoSH, the Supreme Court now, that can help you. But if you going as part of the law bill director, that is not happening. We have more than 600 laws, not have that guideline. What should be the conclusion? That is in the interpretation of either the judgment or the hearing done by the advocates also, then they will be decide either evidences are there or not. It will, so it will not expect, it is, it need not to expect by the organization. It is on the organization you have to be assured, because at the end consequences will be happen to you. Even though if there is any fault happen, you can be either your certification can be withdrawn, or that can be rejected, that can be hold, or you will be punished with some financial losses. Either if the court case went into the court, hearing will be happen after 10 years or 12 years, 20 years, so then after it will be in the consequences or financial charge into the CRs. So now we are here requesting to Monica Singh. So thank you, Radha ma'am, for your opinion.
Welcome.
And Monica Singh, please open your video and I'm going to add you in the pin.
Hello,
okay,
sir.
welcome, Monica, here in this discussion on the
Sir, I have
Supreme Court.
one question.
Yes, please.
I am working in this current organization. The people are talking in the double meaning words. So this is also including in this act. So can I take any action related to the same?
Yes, of course. If it is the court has been defined. However, the further many interpretation has been done. So there is the two thing. What I said, what you receive, it is now up to you. If you perceive that it is the behavior which I do not, so you can first convey to them this is not right way. Otherwise, you talk first with your HR. Then you, there is, if the committee is available into your organization, you can complain to them. So this is come under. Yes, please.
2 and 3 times I complained to my community. I complained to my senior that they are talking in a double meaning words, but they didn't take any action related to the same. So what can I do?
So first, you can also directly talk to those people. Okay. So first of all, if they are not doing, so first you can directly talk to those people. This is not good. This is not good for me. I do not appreciate such behavior, and this is feel me awkward. So you can directly talk to them. If it is not there, you have the other other means also. There are the provision of the FIR also. If it is not there, the organization is required. It need to be sought out by the committee. If the committee is in your organization, however, the 98% organized in the committee that are just on the paper for as and part of compliances. So that is the one reason. But as the, if you have such issues, so you can directly talk there. The opinion I can give it here. If either you can consult with the, some advocates or who can help you in the right way that. But as of now, I just see, or I just opinion on this, that you need to be talk either directly to them. If they are not in, so we have already complained, then you can go to your management also. So next chance is to discuss with some expert also, and they will guide you properly on the matter.
Okay, thank you.
Okay, thank you so much. Okay, is there anyone? So okay, Vivakar is asking, in all your slide, the last line, okay, date is 5/2/22.
Sir, one more question, last question.
Okay, please. 202. Thank you so much, sir. Just give me 1 minute. So here is Vivakar sir has been identify one mistake 202 at the end. So I'm thankful to Vivakar sir. He has been identify this one. So now, ma'am, please. Yes, your question.
Nowadays, we are just going through certain news about PDA in the metro trains, right? Specifically in metro trains, right? Are they can be identified as PoSH? First question. And the second question, if you see, there are a lot of YouTubers who comes and who dance on the street, right? At the public places, specifically vegetable market and bus stands, these places. And these songs are very sometimes vulgar dance and all. So how do you take it up now as a
so if we here we are discussing especially on the PoSH provision. So if it is not till then the physical touch, it cannot be considered, or if it's not the awkward they have seen, they have said something directly to you, till then it does not come under the provision of the sexual harassment. If it is another, you have the local police also, you can go to there. But as of the personally, now it is the too much vulgarity is happening in the society, so it is better for your safe also. So you just assure your safety first. It is my recommendation.
YouTubers are okay. I mean, whatever I was just going through in the certain news channels and even in the live newspaper also, there is a PDA, right? And specifically in metro, it's coming up number of times.
Yeah.
So how this Supreme Court will take it up as a PoSH? Because that includes two persons, obviously two persons, not single.
Even if we talk about the under the PoSH provision, but court, if someone has been go for the PI, then after court will see. Otherwise, court, they are the super people in the Supreme Court or either other court. They do not come to either their near and dear come to with this special case. Like there is the case of recently now happening the same-sex marriage also. They have initiated it by themselves. And there are the thousands of cases happening into the society for the middle class. They are not taking care, even though the many people, they are going into the court, they are striking there, no one taking care. So this is just into the society. That's society for the top people. Here you cannot do. You just have to safeguard.
Again, I mean, I haven't completed because there's so many things comes in mind. Suppose you are a group of people or your colleagues traveling in a train and two of your colleagues does this. So can we lodge a complaint against them? Because this is not
Why not? That is in a public place. You can, yes.
Because this is not a consensual relationship.
Yeah.
Right. They have not given any consent on it.
Yes. Yeah, you can file a complaint. You can go for FIR immediately.
Okay.
You can file it. There is no, because that is about, for example, someone is creating the video. You are in their frame. So it is, they have not taken the consent to you. You can file, you can complain.
Yeah.
It is your right. Without your consent, no one can capture your picture. Even there is the electronics law also, where you cannot use an electronics gadget, or this under the cyber crime also. So you cannot use that. No one can pick your picture without your consent. So that is similarly. However, it will be took many, the police, they have their own thing also. But as of you, as in this citizen, so you can go it. You can file a complaint. But after that action happen or not, it is God knows. Okay. But as of you, for your safer side, you can do. But next is there, if there's someone, you can file an PIL on that. The group of some advocate, they can file a PIL, and then after it can, there some conclusion will be come out. So that may be possibly happen. Otherwise, as a single individual, it is to keep yourself safe. The metros, either there, that is the safe in the public places. So you can first complain there is the
because I'm in Delhi and I come across so many, I mean, scenes every day that I need
who are traveling into the public transport, that it is happening there. So you can, there is also the complaint boxes are there. So you can also, their website is already available, has been launched. There was one case happening recently into the Delhi metro. So then after they have launched one website, or there's some email also, where you can put such pictures and such note also in this particular station it has, because that is videographing is already happening. Recording is already happening inside the metro. So they can track it. But you have to be initiate, but with your safety.
Thank you.
Thank you, ma'am. Okay. Thank you so much, everyone. If there anyone who want to ask or opinionize at the end, because it is now the 10:09. So anyone can raise the hand who want to ask any question, or either they have some different opinion on the provision of the PoSH, or anything that you want to be relate to your organization where you have to be implement the provision. It is for the organization as the conclusion note. So here I personally thank you, Bivakar sir and Radha Sharma, Monica Singh, who has been opinionized and asked the questions to provide you the insight and some really good things what and how you can proceed into your organization. So thank you so much joining this open discussions and becoming the part of our SBR HR Learning Academy. However, who we are, I did not share with you, so that we have to, because 1 hour only, so we have to be just conclude within hour. So whatever who we are, our website, everything we are going to be share with you. Just keep on connect with the. We have been provided you the community also, and in the future there will be also the some discussion, the some thing happening in or which is relevant to the corporates, we are bringing them into the open discussion so that we can discuss here, and the who are the community member, they can get benefited from it. So thank you so much everyone who has been become the part of this open discussion today. However, I was expected more than 50 or 80 number of the people, because we have picked up only 100 number of people out of 200 who are opinionized and to opinion or question into this live open discussions. But here we saw only up till 35 numbers. However, it was a good number for us. But this replay will be available by for tomorrow on our LMS also, where you will provide access, and we are also available on the YouTube. There it will be available for 48 hours. You can rewatch it. Then after we will remove this video. Thank you so much everyone, and good night. Do share your comments and opinion on the WhatsApp and the group so that we can initiate some good learning for the HR community, the corporate community, to building a next level society for the corporates, human beings, or human resources. Either you are the professional into the HR, you are service provider, you are consultant, you are as a lawyer, advocate, where you have your cadre into the social work personally, but better you can do that. Similarly, what better we can do to improve our society that we are doing, what is in
Hello.
limitation to our hand. Thank you so much everyone.
Hello.
Yes, please.
You know my name, Vibhakar, but I do not know your name, please.
Oh, my name is Beer Ram Raja Singhvi. I am the promoter of SBR HR Learning Academy.
Yes. Thank you.
Welcome, sir. So thank you so much, and good night, everyone. So hope soon we are going to be meet maybe next 15 days on the another issue related to the human resources and our corporate societies. Thank you so much. Good night, everyone.